Uh, okay, thank you, Arnie. Well, hello and welcome to you all. Thank you for being here for this special presentation with Pat Parento. Many of us are experiencing these days a kind of a news whiplash with a daily onslaught of events, of actions or actions at the federal level that have kind of left our heads spinning, most of us anyway. At the same time, media coverage of climate-related issues has decreased significantly over the past um, few years as broadcast news consolidates, declining 35% from just 2024 to 2025. The purpose of this presentation is to highlight two recent climate-related events with potential long-term consequences for our efforts to mitigate climate change and its impact on society and ecosystems. Today, we'll be talking about the recent decision by the Supreme Court to hear a fossil fuel company's appeal in a Boulder, Colorado climate case related to seeking damages for climate impacts, and the recent decision by the EPA to rescind the endangerment finding. I can't think of a better person than Pat Parento, an attorney who is fluent in speaking people speak, translating legislative issues into words that we can all comprehend. Patrick A. Parento is Emeritus Professor of Law and Senior Fellow for Climate Policy in the Environmental Law Center at Vermont Law School. He has served as Director of the Environmental Law Center and was the founding director of Environmental Advocacy Clinic, a public interest environmental law firm. Professor Parento has an extensive background in environmental and natural resources law. He has been involved in drafting, litigating, implementing, teaching, and writing about environmental law and policy for over 5 decades. His current focus is on confronting the profound challenges of climate change through his teaching, publishing, public speaking, and litigation. Pat, hello, and welcome to our group. How are you?
Thanks, Lana. I'm fine. I'm out here in Albuquerque, New Mexico, where the temperature has been delightful, I must say. We are located where we can see the beautiful Sandia Crest Mountains.
Wow.
And my wife and I are going to take the tramway to the top of Sandia Crest here shortly. But thank you all for inviting me to join you. I must say, seeing all the gray hair in this distinguished group uh, is heartening, right? I mean, we still, as elders, I guess, septuagenarians and octogenarians in some cases, still have a little bit of fight left in us, right? So, very glad to join you and to see you, see what you are all doing to uh, confront this existential crisis of climate and relatedly biodiversity loss.
Right.
So go ahead, Lana. Do you want to
Yep.
ask me some questions?
I have a list of questions here, Pat. How
I
did you?
thought you might.
So thank you for that gracious welcome to our group, and really happy to see you here. So I'm going to start off. Maybe you can help set the stage a bit. The name of this presentation is Climate Accountability in the Supreme Court. Before we get into the nitty-gritty of specific federal actions and lawsuits that loom before us, could you set the stage for us by explaining the relatively new term of climate accountability and what it is in general terms, and does it relate to, and how it relates to more recent lawsuits?
Right. So there's probably two dimensions to climate accountability. One, the government's accountability for policies and decisions that it has been making now going back five administrations. It isn't it, right now we're all focused on what Trump is doing, but the truth is, both Democratic and Republican administrations have failed utterly to manage the climate crisis, to transition our energy systems and other economic systems into cleaner, safer, more affordable systems that don't involve carbon pollution of the atmosphere, right? So One aspect is what is the government's duty and responsibility, both constitutionally and internationally, for dealing with the climate crisis. The other aspect is what is the responsibility for the companies, the fossil fuel industry that's causing the environmental and climate crisis, right? So, two dimensions, both government responsibility and private sector responsibility to transition away from fossil fuels and the carbon related carbon pollution, and also pay for the damages that climate change is doing increasingly, as we see almost every day.
Thank you. Thank you for that. And it seems that this climate accountability lawsuits is a relatively new term. Does that refer to a specific type of lawsuit? Pat, can you
It
speak?
does. And, when we talk about law, there are various sources of law. The United States Constitution is a source of law, and there have been lawsuits brought by Our Children's Trust, in particular, trying to establish a constitutional right to a safe climate. They have not been successful at the federal level so far, but they keep trying. Then there are also state constitutions, including Massachusetts, that have various provisions that ensure you can argue, ensure a safe climate, or sometimes it's called a healthy environment provision. And Our Children's Trust did score a very significant victory in Montana it's been almost 2 years now. Under the Montana constitutional right to a healthy environment, the Montana Supreme Court did rule for the first time ever in the United States that there is a constitutional right that protects youth plaintiffs in Montana. There are cases like that pending in other states seeking orders from state Supreme Courts. So it's another area to keep an eye on to see if maybe some of these state-based constitutional cases might succeed. And then you have what we call tort cases. These are common law lawsuits, and there are almost 40 of them right now. We'll talk some more about these. And that's what's involved with the Boulder case that's now on appeal to the Supreme Court, and the Supreme Court just recently did grant review in that case. More to say about that. And so then there's a third category well, there's actually more than a third. A third category would be what we call statutory claims. That's where the endangerment finding comes into play, right? So the endangerment finding was made under the Clean Air Act, federal law, and it's now being repealed, and we'll talk about that. And so you have statutory-based claims that the government is not doing what the statute requires it to do. And of course, we have a lot of federal environmental laws that come into play: National Environmental Policy Act, Endangered Species Act, Clean Air Act, Clean Water Act, and others. And then finally, the fourth maybe category would be international law. And of course, once again, the Trump administration has withdrawn the United States from the Paris Agreement, which Trump 1 did before, but now he's done it again. But also this time, Trump has announced that he's going to withdraw the United States from the larger Framework Convention on Climate Change. This is the United Nations Framework Convention on Climate Change. And this one was ratified by the United States Senate. Kind of a rare thing these days for the United States to actually ratify international treaties. But again, Trump has announced that he will withdraw the United States. He hasn't actually filed the paperwork to do that, but we assume he will. And so then there's a question is, how is Congress going to respond to that? So maybe I better stop there. So there are 4 different categories. You can see how complicated it gets right off the bat.
Right.
But that's kind of the universe of lawsuits.
Right. Thank you, Pat. Just a second for our audience, please. I forgot to mention that we're going to ask people to do a raised hand function if you have questions. And if you could kind of hold your questions till we get through the presentation, because a lot of times the answers will come during the presentation. So just a suggestion. So please, figure out how to use your hand raise function if you don't know, and that's how we'll take questions at the end of Pat's presentation. Okay, well, you just referred to, some of the states that have worked on passing climate superfund laws. Vermont and other states have done this. Massachusetts has filed some bills, but they were sent to study. So we're very curious about what happens with other state cases. So where do you think all these court battles will go, and how long will it take before we have some sort of a final ruling and some fossil fuel companies that are actually being accountable for the damage they've caused?
Right. Well, I don't probably have to tell this group that litigation is a long-term, messy process. Okay. So Vermont was the first state in the nation to pass a climate superfund law, followed quickly by New York State. Other states that are looking at it, Illinois is looking at it. I hear Massachusetts is. And of course, this has drawn the fire of virtually everybody. So the Trump administration has sued Vermont and New York, and they've also threatened to sue Hawaii and Michigan, by the way. The trade associations that represent the fossil fuel industry, primarily American Petroleum Institute and the Chamber of Commerce, they've also sued Vermont and New York. The oil companies themselves, which are the, if you will, the target of these lawsuits, seeking to hold them accountable for their fair share. That's the notion of these Superfund laws. I think most people on this call are familiar with Superfund. If not, I can go back over that and explain some more. But the point is, it's a pretty clear doctrine. Polluter pays. That's the essence of it, right? So it doesn't matter that you sold a valuable product. The point is your product caused damage. When you burn that product, you're causing all kinds of provable damage. It has to be proven, but it can be proven in a court of law. And when that happens, then they allocate your fair share based on sort of your market share of the product that is causing the damage. That's a complicated thing. I don't know if we want to get too far into that, but the point is that these cases are at the very first stage, and there's a motion to dismiss a hearing in the Vermont case coming up, if not this month, and I think it is this month, but very soon, on both the Trump administration's attempt to block Vermont from suing, and also these trade associations that have also sued. Oh, and I forgot, don't let me forget, the red state attorneys general have also all weighed in on, 19 of them have weighed in on challenging Vermont and New York. So, it's a kind of a three-ring circus, if you will. So Trump administration, trade associations, red state attorneys general. And the first stage of this litigation is going to be whether or not these cases can even proceed or whether they're going to be dismissed. There's doctrines involved in dismissal. I'm not going to drag you through all of that unless you insist on it. But it's just something to pay attention. Just let's see what happens with this first round of argumentation in these cases. They're not going to go away completely. They're going to keep grinding ahead to the merits, as we call it, right? And it's going to be years. To answer your question directly, we're not going to know anything about any of these cases for a very long period of time. They're all eventually going to find their way to the United States Supreme Court, and that should send a shudder through all of us. Because, as I like to say, at this point in time, with this ultra conservative 6-member majority Supreme Court, that is where environmental law goes to die. That this court is incredibly hostile to environmental law and climate law. So we have a long way to go, and you can't quit. You got to fight. You got to put your best case forward, and then let the chips fall where they may.
Right. And I understand that there's an organization called ALEC that has been around for a long time, the American Legislative Exchange Council, that is sort of preparing template lawsuits, okay, that are being sent out to the different states to use for precisely this purpose, to sort of fight the efforts to hold the fossil fuel companies, corporations responsible for what they're doing. So we've got a long road ahead, is what I hear you saying, Pat. Well, thank you for that. One argument we hear as a rationale for the states not wanting to pass these Superfund laws is that they will be hit with costly litigation. How important is it for more states to take on this fight? What should the message to politicians and the public be about why we should pass a law to make polluters pay?
Right. Yeah, I warned the legislature in Vermont about this. I said, do not underestimate how much it's going to cost to both defend what you're doing and then to prosecute the claims that you're going to be making. The oil companies led by ExxonMobil, I've been involved in one way or another, either commenting on, advising on, reviewing, writing about these cases for, I don't know, 20 years. I've never seen a more determined industrial effort to make anyone who challenges them pay dearly, and I mean it.
Right.
They will go after individuals. They will sue you individually. They've done that. They've sued mayors, county commissioners, attorneys general. It is a no holds barred kind of litigation, junkyard dog kind of litigation. That's what we're involved with. And once you've made a decision to go, you got to stick with it, which means appropriating millions of dollars, okay? Millions of dollars over time in these cases. You cannot think that you can win these cases on the cheap. You can't do it. As far as other states are concerned, I think I got to defer to individual states about whether it makes sense for them to pass Superfund laws or whether it just makes sense for them to team up with Vermont and New York and help those states defend what they're doing. Defend primarily with both legal support. I mean, this is going to take a lot of lawyers because there's a lot of issues. So, other attorneys general office weighing in with legal support, expert testimony support will be critical. I don't know about financial support, but obviously that would be helpful as well. Maybe a joint defense kind of fund or something like that. So the point is, it is going to take a coalition. And frankly, it is blue states. We're not talking about any red states here. It's going to take a coalition of the strong and the willing to see this fight through. I think there is a better than even chance for the states to prevail in one or more of these cases. And once they do prevail, once they return a sizable verdict, that is going to change things dramatically. That's an inflection point for the banks and the investors and the financial markets when they see that the law has finally caught up with the industries that are causing this damage. That is going to lead to meaningful change.
Let's hope, because climate change isn't going away, no matter what they try to do to get people to avoid the issue. It's just getting worse, and it's costing us a fortune. So we're going to have to pay one way or another. And I'd like to see the effort put into funding the cases against the fossil fuel industry.
Lana, I see that Jean has her hand raised.
Oh, okay. Yes, Jean.
Thank you. Pat, I'm remembering Love Canal lawsuits that turned out to be successful. I'm remembering the state's attorneys general suing the cigarette companies and being successful. How do those two prior cases perhaps play a part in what we're talking about in terms of the state Superfund laws?
Those are good analogs. Here's the difference. In this case, we're talking about global pollution. That's the big difference. The tobacco cases, totally the United States. Love Canal, not only the United States, New York State. So the precedent of polluter pays is very strong in our law, foundational principle of law. What's different is this notion that the real damage is coming from all of the sources throughout the world, because as we know, greenhouse gases, all 6 of them, are well mixed in the atmosphere. Doesn't matter where they come from. It's all resulting in the damage that we're seeing in the fires and the floods and the drought and the heat waves and all the rest, sea level rise and all the rest of it. So that's where we're at the cutting edge of law. And that's why I say ultimately the Supreme Court is going to have to decide, is there a remedy in U.S. domestic law for global pollution? That's the biggie.
Okay, thank you. And I'm going to need an assist from other members of our team because I can only see a small sample of the people on this presentation. So if somebody else sees a hand raised, please let us know. All right. Well, you've already touched a little bit on the Boulder case. What is the significance of the Supreme Court taking on this case?
Yeah, this is very significant and troubling because the Supreme Court has had prior opportunities to take cases like Boulder. The principal one is from Honolulu, from Hawaii. And the Supreme Court denied review in the Honolulu case. Here's some of the interesting backstory going on here, okay? In the Honolulu case, Justice Alito recused himself because he has substantial financial holdings in Exxon and at least one other major oil company. However, so in the Honolulu case, the court couldn't get the 4 votes necessary to review it. We know that Justice Kavanaugh wanted to review it. We can assume Justice Thomas would also agree with that, and probably Justice Gorsuch. But without that 4th vote, they decided not to take Honolulu. So the fact that Alito all of a sudden discovered he didn't really have a conflict in the Boulder case, that led to at least 4 votes granting review, okay? Now, here's the interesting thing about Boulder that's what I would call a little bit of a sliver of light. And that is the court not only took the case based on the issues that the oil companies presented to the court, but the court added a 3rd question. And this 3rd question goes to whether or not the court actually has jurisdiction over the case at this point. And that's because there's been no final judgment in the Boulder case. What the Colorado Supreme Court ruled was that the case could go to trial. That's all. Denied motions to dismiss the case, allowing it to proceed through discovery and ultimately to trial. So the argument here is normally a winning argument, which is the Supreme Court doesn't jump into cases when there isn't a final judgment. There's actually a statute that says they're not supposed to do that. Of course, we know the Supreme Court will do whatever it decides to do, regardless of the niceties of jurisdiction, and even regardless sometimes of precedent. We saw that with the overturning of Roe versus Wade, right? So and overturning of Sackett, 50 years of Clean Water Act jurisdiction. So what I can say about Boulder is this. The argument has been scheduled for the fall. The parties have been ordered to brief this jurisdictional question. So there's a slim hope, that's the way I'll characterize it, that when the fall comes around, the court will decide, well, you know what? we're not going to take the case. We're not going to go to the merits of the case right now. We're going to let the cases play out a little more. But if I'm wrong, and I usually am with the Supreme Court, and the court decides to go ahead with argument, then we're going to have to wait and see what the actual ruling of the court is. The worst case scenario would be a ruling that all of the lawsuits, the Superfund lawsuits and many other theories of recovery for damages, are all preempted by federal law. This is what's going to tie us into the discussion of the endangerment finding, which I'll hold for the moment. Yeah, so the worst case scenario would be the Supreme Court rules none of these cases can go forward. Massachusetts was poised to go to trial on the consumer protection case that Governor Healy and former Attorney General Healy filed, right? So you were in the lead. Massachusetts was going to be the first case to go to trial against the oil companies for their deception, right? Their false advertising, right? But with the court now saying they're going to review Boulder, that puts a cloud on the Massachusetts case and all the other cases. We've already seen one of the judges, in response to what the Supreme Court has done, put a freeze on the case in his court out in Washington State. So that's one of the immediate effects of the court saying we're going to review Boulder, is it freezes all these other cases that would be normally proceeding to trial. So maybe I'll stop there.
Thank you, Pat. This conversation raises the issue of a couple of things in my mind: ethics in the Supreme Court, and also the issue of money in politics. And what we're looking at is having to fight against basically a behemoth industry that has unlimited amounts of money to fight this. I'd like to think that the desperate efforts that they're making are because they are concerned that we're making headway. Maybe that's a good sign. I'm looking for anything positive here.
Yeah.
So, okay. Well, you've mentioned already the endangerment finding. I'd like to move on to that. One of the most concerning actions from the current.
Pamela's got her hand up.
Oh, thank you, Pat. You're good at this. Pamela, sorry. And I can see you actually. I just didn't see your hand. What have you got?
Yeah, sorry. There's also the devastating Humphreys Executor, I think is called, where the EPA, where the Supreme Court decided that Congress had to make all of the details of all the regulatory laws or they couldn't be used. Instead of allowing the expert scientist organizations that the government puts together to make the detailed enforcement regulatory rules. Congress has to do it.
Yeah, you might be thinking of what we call the major question doctrine. Is that what you're thinking of? Humphrey's Executor deals with a different issue.
The one where the EPA is no longer allowed to decide what the regulations are that regulate the greenhouse gases or the actual pollution, because Congress has to put that in the law.
Well, that's what Administrator Zeldin is arguing. If we get into the discussion of the repeal of the endangerment finding, that is what Zeldin, who is the current EPA administrator, is arguing. He's arguing the statute isn't clear enough, but that's a really complicated question. Do we want to get into that, Lana? You tell me.
No.
Pat's saying no, so Pamela rather. Well, thank you. Yeah, there are a lot of complications here for sure. I think let's talk about the endangerment finding a little bit. It's a recent decision to rescind the endangerment finding. Can you explain what the endangerment finding is and why this recent EPA action is so concerning?
Sure. So this comes from Massachusetts versus EPA. Thank you, Massachusetts, for winning the landmark decision. This is a 2006 decision by the U.S. Supreme Court, a 5-4 decision, showing you, that these really difficult, big issues frequently result in a very close vote. And in that case, the Supreme Court ruled that the Clean Air Act does regulate greenhouse gases as a, quote, air pollutant, which common sense would tell you they should be regulated. And the Supreme Court said common sense is right. They are regulated. The backdrop here, this was the George W. Bush administration. You may recall that when he came to office under the influence of Dick Cheney, he decided that his administration was not going to tackle climate change, right? And so he directed his EPA to take the position in the Supreme Court that EPA lacked authority to regulate greenhouse gases. And as I say, the court ruled 5-4, yes, you do. And then secondly, and this is the important point, the court said, when you make a finding that these greenhouse gases endanger public health and welfare, you must regulate all of the at least significant sources of the pollution. Cars, trucks, planes, boats, trains, right? Mobile sources and stationary sources, power plants, cement plants, fertilizer plants, oil refineries, and so forth. All the major industrial categories, all the major mobile sources of greenhouse gases, right? So that's why
John?
I think we have somebody.
Excuse me, Marie, yeah, there you go.
So two big holdings from Massachusetts versus EPA. One, EPA has the authority to regulate, and two, EPA must regulate once it makes an endangerment finding. The endangerment finding was made by the Obama administration in 2007. So, it's been on the books for what, almost 19 years, something like that.
Right.
My math's not great. So now along comes the Trump administration, and right from day one, Trump said we're going to repeal all of the climate rules, and they followed through on that. I have to say, I did not expect the Trump 2.0 to be as successful, devastatingly so, successful in gutting our environmental laws and our environmental institutions. I mean, gutting them.
Right.
The damage that's been done so far, it's going to take years, if not decades, to repair. So I hate to be negative, but I owe it to you to tell, based on my 55 years of doing this stuff, I've never seen anything like it. Nothing comes close.
I think a lot of people have been stunned by the speed, but it was in the works prior to his taking the presidency. So it was very, very calculated. And the idea was we're going to blast them with everything and do it right away. And like I said, whiplash for the rest of us. Very difficult to fight the way they've handled this. And they don't mind dragging things out through litigation, apparently. So anyway, any hands up? No. Okay.
There's a hand up from Edward.
Have there been any?
Hand up, Edward.
Oh, Ed. Hi.
Hi, thank you.
Ed?
Thank you, Pat. This is terrific. I have a question is, does the repeal of the 2009 endangerment finding and the lack of federal legislation and regulation of those 6 greenhouse gases open the door for more robust state regulation without the fear of federal preemption?
Yes, it does. California has already announced, they don't want the endangerment finding to be repealed, but they are warning that if it's repealed, they will move forward to regulate not only mobile sources, and of course, California has had what's called the California waiver ever since the 1970 law, and that has frankly been the standard that has driven the automotive industry. Each year, California has been tightening, ratcheting down on those standards. So yes, one, looking ahead and assuming a lot, by the way. First, we have to assume that the repeal of the endangerment finding is upheld, right? Not only by the DC Circuit, which is going to review it, but also by the United States Supreme Court, which means the United Supreme Court is going to have to reverse its ruling in Massachusetts versus EPA
Right.
in order to agree with Zeldin that EPA, it turns out, doesn't have the authority, right? So I'm not willing to say that's going to happen, but if it does happen, one of the consequences will be California and other states will have authority that would otherwise be preempted. Another consequence, as long as we're talking about them, I'll mention quickly, is that the lawsuits against the fossil fuel industry, the oil companies in particular, they will also be allowed to proceed to trial, because the oil companies' main argument against those cases is that they are preempted by the Clean Air Act. And they've actually won 10 dismissals based on that argument in state courts, right? So if in fact the Supreme Court rules in agreement with Trump and Zeldin that EPA doesn't have the authority because the Clean Air Act doesn't regulate these pollutants, then voila, there's no preemption. So in, true ironic fashion, the Trump administration's arguments are going to backfire big time if they win. And I'll stop there.
Well, okay, thank you. Okay, we're moving right along here. What are the chances that the EPA finding will end up in the Supreme Court? Do you think there's a high likelihood of that, Pat?
I do. Here's one scenario where they might not, and that is, I mentioned that the first round of review will be in the United States Court of Appeals for the District of Columbia, what we call the DC Circuit, right?
Mm-hmm.
Now, that circuit has a mix of appointees from Democratic and Republican presidents. So it's a more balanced court than you would find in, for example, the Fifth Circuit is radically right wing. So the DC Circuit right now is both really expert on issues like this. This is the court that hears all of the challenges to major rules under the Clean Air Act. So their bench, the judicial bench, is deep in expertise on this stuff. The Administrative Procedure Act, the Clean Air Act, the history, and so forth. Number one. Number two, there's a good chance that the panel that is assigned to hear this case, it could include a Trump appointee. In a kind of a worst case scenario, it could include 2 Trump appointees, right? Mm-hmm. But there's a chance, I think, that the DC Circuit, because some of the flaws in the record that's been developed are so profound that even a really conservative panel of judges on the DC Circuit is going to have a really hard time upholding what Zeldin has done. Mm-hmm. Not least of which, the DC Circuit cannot overrule Massachusetts versus EPA. It cannot agree with Zeldin that EPA lacks authority. The Supreme Court has already said it does have this authority, right? So here's the scenario that might keep the case out of the Supreme Court. And that would be the DC Circuit rules that the repeal of the endangerment finding was illegal for any number of reasons, okay, and sends it back to EPA, if it takes long enough for the DC Circuit to reach that conclusion, we're getting close to another administration coming into power, right?
Right.
And the minute another administration comes in, cross our fingers, hope it's Democrat, they can then reverse everything that Zeldin has done, okay? If the DC Circuit does what I hope it will do, invalidates the repeal, and the Supreme Court declines to either take it on review, or time goes by so long that a new administration comes into power before the Supreme Court rules. I don't know if you're still with me, but this is what lawyers like me and law professors like me spend all of our time waking in the middle of the night trying to figure out, right?
Right.
Let me just put it this way, okay? There is a pathway for the repeal of the endangerment finding to be overruled and a new administration come to power and the whole thing go away. There is also a pathway for the Supreme Court to take the case, agree with Zeldin, wipe out the endangerment finding, and then you have the consequences that I was talking about earlier. And if you're totally confused, you're entitled to be so.
Yeah, well, it is convoluted, that's for sure. We will have to stay focused and try to pay attention to what happens moving forward. But it does seem that it's going to take some time. Well, I guess one question was implications if the EPA prevails in the Supreme Court. If it does go to the Supreme Court and prevails, what recourse do we have to fight it?
Well, I think that's the broader question of what do you do while all of this crazy litigation
Right.
is playing out in the background. You don't, I mean, you can think about filing an amicus brief if it gets to the Supreme Court. I think a distinguished group of elders from varied backgrounds could actually do something useful in that regard. And if you want to follow up on that, I'll have some suggestions for you.
Great.
There are plenty of environmental law clinics, mine included, that would be more than happy, frankly, to work with you on an amicus brief. So if you were inclined to stick your nose in the meat grinder of litigation, right, there's a way to do that. But I think the more important thing to think about is the following. Not only can Zeldin and Trump not repeal climate change, they might try to repeal the endangerment finding, but they can't repeal the danger.
Right.
And the danger is only going to get worse. So that means the role of states and cities and towns, for that matter, counties, is paramount. I mean, I have to say, I don't have a whole lot of faith in the United States government right now. And it isn't just Trump, it's Congress.
Yeah.
And I know we're going to make some headway this year on the midterms. I know that. I know the Democrats are going to take back the House. I don't know by what margin. I don't know about the Senate. They have an outside shot at that, but we can't count on that either. But the point is, it's hard to see a return to Congress taking a really strong, effective action on climate. That being the case, I mean, we keep working at that, right? We try to send better people to Washington, D.C. for sure. But in the meantime, there's an awful lot that can be done at the local level on supporting clean energy. And I know Massachusetts is doing a lot of that. It can probably do more. The Regional Greenhouse Gas Initiative, RGGI, was a tremendous step forward, but it's still inadequate. There was an attempt to try to have it expand to include mobile sources that fell apart. That needs to be regenerated because we know that we can't get to where we need to go without transitioning away from gas guzzling cars to electric vehicles. The good news is, and I shouldn't go on and on and on. The good news is renewables are the way of the future. Okay. Solar and wind and geothermal and battery technology, storage technology, smarter grids, all of those are the way of the future. That's inevitable. Trump can't stop that. The Congress can't stop that. So the economic case, if you will, in the parlance of today, the affordability case is all about green energy, efficient energy, and efficient vehicles, and electrification of everything we can electrify with clean energy, electricity generation, right? So I'll stop there, but the opportunities to get involved in moving us towards a better future, a cleaner future, they're limitless. They literally are limitless. And I'll stop because I see hands up.
Okay, thank you. I'm going to call Sherry and then Tina and then Pam. So Sherry, do you have a
Thank you very much, Pat. This is quite helpful. So in the litigation that's been filed, have you seen have any of the oil companies weighed in on the litigation? Because I think there's a big risk to them. And then my question is two-part. If this goes to the Supreme Court and the Supreme Court overturns the endangerment finding, would they also have to overturn Massachusetts versus EPA?
So on the first point, the oil companies themselves have not yet entered the cases challenging the climate superfund laws, Vermont and New York. They are letting their surrogates take the lead on that. As I mentioned, that's primarily the American Petroleum Institute and the Chamber of Commerce. Okay.
Okay.
The oil companies are waiting in the weeds to see what happens. They're obviously aggressively pushing the Supreme Court on the Boulder case and to rule more broadly on all of these cases, including climate superfund type cases, right? And have the Supreme Court declare they're all preempted, right? So that's the way the oil companies are playing the game right now. But they're also seeking immunity. Okay, they're seeking immunity in Congress, and I think Lana mentioned ALEC, right? So ALEC has now introduced bills, and in at least two cases have passed into law, granting immunity in red states. Okay, so that's the way the oil companies are playing the game right now in responding to state initiatives. Then on the question of if Trump is successful in repealing the endangerment finding, that goes to the point I was trying to make earlier, which is, the oil companies' main argument against all these state liability, as we call them, cases, is that they're preempted by the Clean Air Act. So if the Clean Air Act goes away, preemption goes away. Now, we don't know exactly how this is all going to, you know how we like to say this in New England, how it all sugars off, right? We don't know. We won't know. This is all brand new stuff we're talking about, right? So we're years away from having any clear answers to this litigation stuff.
Okay, well, Tina, you have a question.
Yeah, thanks so much, Pat. It's really great to hear from this perspective. Going back to what I have two questions. Going back to what you say about what advocates can do in the meantime, when the lawsuits against the tobacco company were successful, all the thousands of documents, reports, etc., came out that showed that they knew what they were doing. And that was really useful because then the public health community could devise advertising and also against the industry, and also provide the basis for some state laws to get rid of advertising and sales to youth, et cetera, Is there something along those lines that, even though these lawsuits haven't gone to court yet, that advocates could be doing by using the findings or documents or reports from the industry?
Oh, absolutely. So a couple of thoughts on that front in terms of what people can be doing while all this litigation proceeds. One, there is a wealth of well-documented evidence of what the companies knew, when they knew it, what business decisions they were making based on their understanding of the threat of climate change. Things like, by the way, raising their platforms for oil drilling because they knew sea level rise was an issue. They knew that storms were going to be more intense, and also going into the Arctic and doing more exploration because they knew that the Arctic was going to be ice free year round at some point, which meant that all the oil and gas reserves of the Arctic, which are enormous, would be available, right? So they were making business decisions. We're talking about going back to the 60s, 70s, and 80s, making internal business decisions based on their own scientists telling them what the threat of climate change was and how severe it was going to get, right? And then lying about it. So, and I'm using that word advisedly, lying about it in the documents that they filed with federal regulators, in their annual reports to shareholders, lying about what they knew, trying to create the image or the perception that the science was unsettled. You can go back and find statements from their top CEOs saying the science is still unsettled. It might be a problem, but we need to study it, right? So you got all of that enormous amount of information. Now, what do you do with it? What you do with it, if you want to influence even indirectly the litigation that's trying to hold the companies accountable, is you say, who should pay for all this damage?
Let's figure out how to get out of this thing.
Again, the companies are seeking immunity, understand. There's bills in Congress to grant them the same kind of immunity that Congress granted the gun manufacturers after Newtown. After Newtown, the gun manufacturers got immunity from anything they were selling, no matter how lethal in killing kids and other people it was. They got that immunity, right? So we know the oil companies know they're liable. They know they're causing damage. That's why they want immunity, right? Okay. Right. So who's going to pay for all this damage? That's what it comes down to. The political dimension of this is who should pay? Should the oil companies pay nothing? Zero? That's their position. Zero is their contribution, right?
All right.
So you're going to pay.
So I'm wondering, again, going back to tobacco, what they were successful at is getting ads and advertising to bring out those lies and to, especially around targeting youth. And we're successful. So I'm wondering if one way that advocates can be working would be to devise advertising and ads and literature, et cetera, to educate the public and change the perception of and maybe even laws to say they can't advertise their products because it's deceptive.
That's your lawsuit. That's the Massachusetts lawsuit. If you haven't seen that, you should go take a look at the complaint. That's exactly what the Massachusetts is seeking in its case against Exxon.
Right. And so right now, but that's stuck. I'm wondering if there's more perception of the public that needs to be in education that needs to be done around that. Yeah, thank you.
Yeah, sorry. That was too long-winded. Sorry.
Okay, I see Roger and Pam. Roger?
Quick question about the repeal of the Chevron doctrine and what effect that you're going to see that's going to have with regulations on the federal level and on the state level as well. What do you see the impact being of that?
Well, ironically, again, one thing is that Zeldin can't take advantage of it. So he doesn't get any deference either. Okay. So that repeal of Chevron cuts both ways. I've lost more cases to Chevron than I've won. Okay. So, Chevron can shield bad decisions by the government as well as, invalidate good decisions. Okay. So the fact that there's no deference, that doesn't bother me one bit. These things should come down to how strong is your argument for the interpretation that you're making of language in a statute, which may not be crystal clear. Let's face it, the language rarely is crystal clear. Okay. I mean, literally, I've done this 55 years, so I know. So I don't worry at all about repealing Chevron. I'm happy to see it. And Zeldin doesn't benefit from that one bit. And what was the other part of your question? I forgot. I got one carried away.
That was what the impact was. And does this apply also on the state level?
It doesn't apply on the state level, although here's what happens. Some states, particularly again, red states, are going to look to the narrowest interpretation of agency authority, right? So they would cite the Loper-Bright case, which is the one that repealed Chevron. They would definitely pick up on that. And some individual justices, whether they're red or blue or and in between, they would look to a Supreme Court decision like that for guidance, but it's not binding.
Okay. Yeah. Well, just a quick follow-up. You seem to say very, very strongly, unlike what I've heard from other kind of progressive policy nuts about this stuff, who were very much concerned that this was a big blow to progressive regulations. You really seem to feel like it's the opposite. Just a little clarification on that.
Well, I think it's the opposite when it comes to Trump. I don't think it's the opposite when it comes to a more enlightened EPA that's looking to anticipate problems that weren't clearly understood when acts like the Clean Air Act was passed, but have become clear since then, right? Mm-hmm. When science has developed to the point where things that we didn't really think, forever chemicals. Was the term forever chemicals even in the language in 1970? Of course not. No. Was climate change in the language? Of course not. So, I will say that deference to agency interpretations of statutes that identify areas of concern but don't pinpoint exactly what the threats are, I do see losing deference in those situations to be a problem, okay? So the progressives that you're talking about are looking at that kind of a scenario. My feeling is if we had a functioning Congress, all of these laws, none of the major environmental statutes have recently been updated. The last major update of the Clean Air Act or any other federal environmental law was 1990, right? So, thinking about this as how should this actually be dealt with? It should be dealt with by Congress updating these laws to take account of what the science is telling us are the new threats, like plastics, microplastics. Who knew that microplastics were in all of us? Who knew that the CDC analysis is forever chemicals are in all of us, right? 99% of us. Yeah. So yes, there's a legal question as to whether those things were anticipated when these laws were passed in the 70s. Well, if that's the case, then update the damn things and deal with the threats of today. Don't expect the courts to stretch the law in the direction of agencies interpreting these older statutes with ambiguous terms in them, because that can cut both ways. That's what Zeldin is doing right now. He's trying to say the best reading of the 1970 Clean Air Act is that it only dealt with localized pollution. That's the language he's using in his decision. Localized pollution, right? That's not true, but that's what he's arguing. And he wants deference on that interpretation.
Got it.
So
okay. I'm voting for you for Congress for sure. Thank you, Pat. I think Pam is up.
Well, I just want to say the only issue is we need a functioning Congress, right, Pat? So
yeah, there's Alan.
Okay, and also Alan and Pam. Pam, we haven't heard from Alan.
Oh, Pam, yeah.
Is that okay? Okay, Alan.
All right. Thanks, Lana. Pat, thanks. Thanks for all this. I'm a longtime listener of you on Living on Earth, and I hope you continue to do that. That's great. So I'm a retired environmental lawyer, used to be in the Mass AG's office. My colleague Jim Milkey argued Massachusetts versus EPA.
Yay!
And so I'm wondering, you sort of alluded to this, if the Zeldin team is successful and they get to the Supreme Court and they win and Massachusetts versus EPA is overruled, they're still going to be arguing preemption. How are they going to do that?
I don't know. How do you think they'll do it?
Well, they're going to argue that there's this statute over here and this one over there. And, I don't know.
This is what I've heard, okay? They're going to make a constitutional preemption argument. There's no precedent for it. But what they're going to say is the United States Constitution cannot empower individual states to litigate a global pollution problem. That's what they're going to argue. And if this would be a brand new doctrine, but that's what we got with Major Question. That came out of, well, not out of nowhere. Some people who claim that are not right either. But it was manufactured by the court to justify overturning Obama's Clean Power Plan and coming up with this new doctrine of if an interpretation of a long extant statute, an old statute like the Clean Air Act, results in a new interpretation, novel interpretation with big consequences, political and economic, then Congress has to speak in the most precise and unmistakable language to give the agency that authority. That was invoked in the recent ruling on tariffs. Okay? So Chief Justice Roberts, who wrote the majority opinion in the tariffs case, invoked the Major Question doctrine and said, that emergency authority that Trump was claiming authorized these massive global tariffs didn't authorize that, right? So we know the Major Question doctrine is probably the biggest threat to the endangerment finding, okay? And, if I were being paid the kind of obscene amounts of money that the oil industry lawyers are being paid, I would stand up in front of the Supreme Court and say, there's no way you can interpret the Clean Air Act as authorizing the regulation of global pollution, period. Sit down.
Great. Okay. Well, Pam?
Go ahead with Edward.
Okay, Ed. Ed, I think you're muted. You have your hand up? Yeah, okay. Do you have a question, Ed? Okay, well, I'm not sure what's going on with Ed, but
I
Pamela,
saw him unmute himself, but we can't hear him.
no, can't.
He must be having technical difficulties.
Can you hear me now?
Yes. Great.
Okay. Is another defense against preemption the Interstate Commerce Clause, where the states regulate greenhouse gases that cross state lines, that would be imposing an imposition prohibited by the Interstate Commerce Law. It's similar to what the court decided out in California, where the state couldn't regulate greenhouse gas emissions from stoves.
Yes, that's what's called the Dormant Commerce Clause doctrine. Right. Yeah, yes. And that is being raised in the case against Vermont and New York.
Sure.
That's different than the preemption case. Yes. And that turns on whether or not the effect of the state laws are discriminatory against interstate commerce. That is one of the issues that the court in Vermont is going to have to decide as to whether or not that claim can at least go forward in the case, whether or not it's ripe right now is another question, because in fact, the state has not imposed any costs on anybody. I mean, we're still probably a year or more away from Vermont sending a bill to Exxon and the other oil companies for the damages, right? So, but I think ultimately the Dormant Commerce Clause issue has got to be resolved. And that's another one that probably has to go to the US Supreme Court. The last time the Supreme Court, and this was an opinion by Justice Gorsuch, dealt with the Dormant Commerce Clause, this was a case involving California adopted a law, get this, regulating the way pigs are raised in North Carolina, right? Wow. It was an animal welfare provision and said, we're not going to buy your pigs if you don't confine them in a humane way. And I thought for sure, in fact, I foolishly predicted this on Living on Earth, that there's no way the Supreme Court is going to uphold California regulating how pigs are raised in North Carolina. But guess what? They did. They did uphold that. So my point is, I don't think it's a slam dunk either way on the Dormant Commerce Clause. It's a very fact-intensive determination. We'll wait and see what happens.
So it's a pig and a poke.
Yeah, there you go. I like it. That's a good one. I'll remember that.
Okay, well, we are kind of running towards the end. Do you have a couple more minutes, Pat, to take two last questions?
Sure.
Okay. All right, Pamela, you've been patient.
It was the Chevron doctrine that I was trying to think of before, not Humphrey's executive.
Yes.
Sorry. Three comments. One is the 14th Amendment makes Trump unconstitutional in fact, since he's been adjudicated in Colorado as an insurrectionist. And the 2/3 of Congress did not remove that bar for him to be in office. So therefore, he is illegal unconstitutionally. There's no way of enforcing the Constitution if people roll over and let it be broken, right? And all that does is set precedent that we can ignore the Constitution whenever we want. Two, when the Supreme Court was conservative in the 19th century, its rulings, when people were trying to get rid of slavery, the rulings made it so that all of the legal routes of graduated compromising that would lead to the diminishment and the elimination of slavery got overturned by the conservative court, such that the only thing they could do was war. And I'm worrying that climate change is the current slavery problem. There are people that truly believe this is nonsense and that it isn't a problem, and those that know the science are really stuck. So we have to do an make emotional and economic arguments for why we're better that would appeal to someone who doesn't believe it's important and hates wokeness. And that's the Supreme Court and Trump and the Trump administration. And also what happened to Citizen Climate's lobby's plan to tax greenhouse gases and pay it out in equal shares to the citizens, like the Alaskan Oil Fund does.
It failed, Pam.
Well, it hasn't officially failed. It hasn't succeeded. There's a big difference.
Well, it
But
has.
that's the one that we need to push because it has the economic and emotional arguments. It would benefit everybody. universally and equally.
Maybe Pat could just quickly weigh in on that. What do you think?
Comment, Pat?
Because it goes
I
at
lost
the,
the thread a little bit. So is the question about a tax?
no, the tax and dividend,
Yeah, the
carbon cashback credit checks. The
Well,
thing
that's
that,
the most efficient way to impose a price on fossil fuel for sure.
yes, and it benefits the poorest.
Yes, and the example is Washington State and also British Columbia. They
Right.
have the two most successful carbon taxes in North America. And they are incredibly popular, by the way, with people across the political spectrum.
And that's the important thing. And it
Yeah.
also goes after the other existential threat besides climate change, which is economic inequality.
I don't know what the prospects for legislation in Massachusetts are, but it's worth looking into.
not moved very far at all in the last several sessions, but there are some folks who try to keep it alive. So,
Started
And if
working.
you want an expert on that, my colleague Janet Milne is a world-class green tax expert.
Okay.
right there.
We are up against a really good propaganda from the fossil fuel industry and the Coke and Alex. They're all together, and we don't have anything to counter it.
Yes, you do. You got your voices.
Yep.
Yeah, and you and us, but we need some powerful super PACs, and we need to co-opt Elon Musk back, who is on our side.
Maybe.
Well, that's another discussion. I think, Jane, would you like to ask a question before we break?
Thank you. This will be a quick question. I'm wondering, Pat, is there a category of common law, common good, the common good or law of the commons type law or laws that could encompass what we have been talking about today? Would that be another way to look at potential legal options for presenting these cases?
Yeah, I would say the public trust doctrine is the one that comes to mind. And Massachusetts has a very strong public trust doctrine, right? Normally, historically, it's associated with navigable water and the beds of navigable rivers and, of course, the coastline. But it's been expanded. And two of my colleagues who are real experts on the public trust doctrine are Michael Blum, B-L-U-M-M, Michael Blum, and Mary Wood. Michael is at Lewis and Clark Law School. Mary is at the University of Oregon. They have a treatise on the public trust doctrine. I highly recommend it. So go get it, read it, and see if you can't get one of them on your program.
Okay. Mary, did you say Mary Wood? I'm sorry.
Mary Wood.
Okay, great. All right. Well, with that, I think we are going to move on to the next phase of our meeting after thanking you, Pat, for your answers. I think we picked the right person to discuss these issues. And I want to thank you very, very much for giving us your time. I know you've got a tramway to catch, so I hope the line holds. And thank you for that invitation to work with your environmental group that does work with citizens around things. We will be discussing that and see what we can do.
Good. Well, it's been a pleasure being with you. Hang in there. We will prevail.
Okay.
Thank you, Pat.
See ya. Bye.
Thank you.
Thanks.
Tina, am I turning it over to you now so you can?
Well, thank you, Lana, for hosting Pat and getting him to come today. It was really interesting and provides a real nice, larger framework for discussion and perhaps ongoing work with our allies as well, specifically here in Massachusetts. So thank you for that. And so I think now we want to turn it back over to announcements, to make a few announcements before we open it up for some discussion about what Pat and talked about today. Seth Evans, I see you here today. You have a couple of announcements to make.
Thank you, Tina. Very quickly, we are in our annual fundraising period. we do this once a year. We ask our members, and particularly our members who are active, to just help out a little bit. We are a small organization. There's nobody that's paid. Any contributions go to supporting our communication, education, and advocacy work. Our budget is very small. It's less than $5,000 a year. And if you've participated in any of our meetings or deep dialogues, I know that you've gotten some value that's worth at least a small contribution to our fund. We have a convenient way to donate, which is a button on our website. I'm going to put it in the chat right now. Again, we have a small budget. Leadership team contributes a good portion of that budget, but we do need help from our members, and we would appreciate anything that you could donate, large or small. So if you have questions about how to donate or anything like that, you can contact me, but the link for donating directly online is in the chat right now, and we'd appreciate your help. Thank you so much. Another very quick message is that announcement, is that we're starting a joint climate change course, a 5-session course. It's going to be starting today, and it's being done with Third Act Massachusetts. We are looking for all sorts of ways to cooperate and collaborate with our partners here in Massachusetts, and this is the second time we'll be doing the class. There's room for a couple more people. You'd have to commit to the next 5 Tuesdays, and I know it's late notice, but if you wish to do so, you could also contact me today. It would have to be today at that same email address, and we could probably squeeze in a couple of more people. In any case, it's a climate class that's mostly for people who are concerned or perhaps alarmed, but not active, and who are looking for to gain greater confidence so they can speak to friends, family, etc. about climate change, or participate more actively in any organization that it might be a part of, or to have the confidence to join an organization. There are also opportunities to help teach this class, either online or in person. If you feel that you're very knowledgeable but want an opportunity to use your special talents to teach about climate change, you can contact me as well. And look forward to, if anybody's going to be in the class tonight, I see a couple of people, look forward to seeing you on Zoom today. Thanks.
Thank you, Seth, for both your fundraising work and for your educational efforts. Jean Wright, that was the class that I was talking about. So you can get that information in the chat, and maybe you can share it with people at Brooksby Village. I know it's a large community there in Peabody. Mayim, you have a couple more announcements to make?
I do. Thank you, Seth, for those, and your class. Remind you of the green resistance bans. So climate people are going to various kinds of actions to do with other things happening and not bringing conversation into the climate. This is a way to signal that we're part of a climate movement. So when we show up at actions, people know. They might ask you, what's your green armband for? You don't have to have a resistance band. I just think it's funny that so many elders have these, right? I mean, you could do a piece of green cardboard and staple it around your arm. So we really want to do this for the No Kings event coming up on 3/28. We are hoping to make this the biggest turnout. They've gotten bigger as we've had a couple of them in the last year. This is No Kings 3. If everybody who goes brings one more person with them, it will be the biggest turnout mass protest ever. There is a point to doing those. You don't have to go to the big one in Boston. There's many, many local ones, or wherever you are. The point is just to go and to follow up No Kings with moving towards Earth Day and Earth Week events. So we'll have our deep dialogue shifted a week early to be April 20th with Arnie on meeting our 2030 goals, and probably how we're not meeting our 2030 goals. So that'll fit into Earth Week. I want to mention that Third Act is having an event with Bill McKibben live on the Common on Sunday, 4/19. You can find info about our events and our allies like Third Act and 350 on our website calendar and on our Facebook page. There are links to those in the announcements that are sent out. Makes it really easy for you to take a look at those. Any day when you want to go, oh, what's happening in the environmental community, just go look at our website calendar under the Get Informed section and you can find stuff to do. So I think that's it for me. Oh, I wanted to say our newsletter came out yesterday. And I don't know if you noticed, but we had several articles that were contributed by members. We're always very interested in those kind of contributions from our members. So if you have something that you're thinking on and want to get something out about it, you can send them to me or anybody in the LT, and we'll take a look at that and maybe have some communication about it and see if we can use it in our newsletter and get your ideas out there, okay? I love it when we have stuff like that in the newsletter. It's a good thing.
I just want to make a quick comment. At the start of the presentation, I talked about the fact that climate news coverage has gone way down. I mean, it's very, very noticeable, particularly in the last few years, and last year in particular. That's by design. The people who are taking over the news media are not supporting climate coverage. So that is one of the reasons why we're interested in this green armband. I personally use green painter tape, very easy to get on. I happen to have some, so it's easy. I also have a green resistance band. Whatever you've got that's green, just to show that we are still concerned about climate, because it's not going away, in spite of all their efforts to make it disappear. It's not.
And there's a point to show up as a climate movement, not, this group and that group. It's like all the groups are showing up as a climate movement. It's really time for our movement to come together and show up. No matter what your issue is, plastics to oceans, forests, just be part of the climate movement.
Betty and Roger both have their hands up.
Yep, thank you. You have an announcement, Betty?
I just had a follow on about the green armbands. I went to the Trees as a Public Good meeting the other night and raised this with them. And they were all quite interested and thought it was a terrific idea also. I also raised it with my grandchildren. So there ought to be some Newton teenagers out on the common with green armbands on the Three Kings demonstration. So I think we all do things like that, spread this idea to all other groups and so forth, and our families and whoever. It'll grow.
Thank you, Betty. Yeah, Roger.
Well, I was waiting for the discussion period to begin.
Exactly.
Okay, well, let's just see if we have any other announcements. Just again, we're having the panel on Friday about the Senate energy bill coming up with panelists. The link I put in the chat, it's also in the newsletter at 11 o'clock this Friday, and we hope you can join us for that. Any other announcements? Okay, I think, Mayim, did you have another announcement?
I just want to repeat my note that I see more people here today from other groups, or I'm not sure how you heard about this meeting, than I've ever seen in one of our meetings. So if you want to get our announcements directly, put your name, email address, and where you live, your zip code in the chat, or you can email it back to mayimbaron@gmail.com, and we'll put you on the announcement list. Thanks.
I think working with other groups as allies is critical if we expect to make much progress. So just really thank you to everyone who's here from another organization. You are welcome.
Great. So Roger, you have some thoughts about the visit from Pat and one of the issues that he raised. Would you like to kick it off?
Yeah, well, I was really interested in what he had to say about make polluters pay, and that does sound like the number of years it's going to take. I knew kind of years, but it even sounded longer than that, the way this is going to wind through the process. with very uncertain chances of success given the Supreme Court, although he seemed to think maybe there's a possibility there. It gave some credence to the concern that states have about taking on a huge cost if they actually kind of jump in and get sued themselves. And he mentioned an alternative, which I'm not sure exactly how it works, about how states can kind of join as a supporter and then don't have to, they can contribute what they're able to, both in terms of expertise and in terms of money. If I don't know if anybody's familiar with what's going on in the Make Polluters Pay movement, but if that as an option is being considered, so speak to the administration about this, or ask the legislature. I don't know if that would be legislation that could pass that would require the administration to step up and do that at relatively minimal cost, but still with, given for what Pat said, probably as big a bang for the buck. I know that was one reaction I had.
Well, thank you for that. I will take that since I've been an ECA member on the Make Polluters Pay Coalition here in Massachusetts. We actually have a meeting today where we're planning the next kind of big step for an in-person strategy meeting, given that the legislation got sent to study for the next legislative session. And maybe we need to bring some more education around that to the group and to move forward. So thank you for that, Roger. I will mention that to them. Lana.
Yeah, with regard to that, I think that I had a conversation with Senator Barrett about that a while ago, about a month ago, and he said that the reason they were holding off on Make Polluters Pay is because they wanted to see what happened with the other states. So it's kind of a game of chicken, frankly, or not chicken, but just wait. So I went back and, there was a bill that was Steve Owens' bill from 2025, I think, and that got Make Polluters Pay, and that got sent to study. So now, we're both the Senate and the House version of that bill have been sent to study, which I think is very unfortunate, but I think that's something we should discuss with our legislators. The other thing that concerns me deeply is that we are talking about the most difficult ways of making change is going through the courts and fighting the fossil fuel industry that has just enormous amounts of money. What we're not addressing is the money in politics. And that's not an easy fight either, but that strikes me as one of the major causes. The fossil fuel industry has huge pull because it donates huge amounts of money to various people in Congress and the legislature that take that money. And that comes at a price to them in terms of, I think, what positions they're taking. I would like us to see more on the state level with regard to getting money out of politics. I think that's really critical. That's my comment.
I don't think it's a separate issue.
Yeah, Roger, then Pam.
Pam can go. I've been already up. Go ahead, Pam.
Do you have more to say, Pam? Your hand is up.
Oh, Pamela, please, ladies and gentlemen. Yeah, I agree. I think we need to make our voices more powerful because we have right on our side, and we can't outspend the fossil fuel industry and the Koch brothers and the ALEC and all of that. But we could leverage what we do if we had like a contract with America type thing these are the things that we want you to support in order to get our collective support and votes, in order to get us to endorse you, such as the Green New Deal, a carbon tax that's paid back out to the people.
Yeah.
And if we combined our little donations into a super PAC, that you would have to sign the contract, to support the Green New Deal in order to get our support. We would be able to recruit the corporatists from both parties to join us because the people are behind it.
Yeah.
Thank you, Pam.
Like-
Roger.
To follow up on that, I mean, I think maybe it's time at the state level to take another look at the carbon tax. As we're talking about this whole affordability issue, one way to kind of spread, make things more equitable in terms of paying for the costs of combating climate change. I mean that maybe that needs to be brought back on the table. It's Barrett has been put it in the mix there for several years. It never went anywhere in particular, but so Pam, maybe at the state level we should be thinking about that.
Because look, it supports the people that need it the most. It eliminates that evil fossil fuel argument that changing this is too expensive for the poor people who can't afford it the least. And this would make it so they would get more benefit from the equal checks they get than the raise in price of energy, and they wouldn't have to use it on energy. They could use it on rent.
Let's think about taking that on next session potentially. I just had a quick comment about. I mean, I was a little disappointed about this endangerment finding. The fact that it sounds like the states will not really be able to take advantage of the potential opening for that until the Supreme Court rules. So maybe somebody got a different message, which means to me, like typically what Trump has done, use the legal system and how slow it is to do all kinds of things that can't be pulled back, that may eventually actually be shot down in the court. And unlike what happened to the tariffs, where maybe the court is going to make them pay it back, it's discouraging and despicable. And I don't know if people got another message, but it sounds like this capacity for the states to do something is going to have to wait, and it's not something we can jump on right now, sadly.
Janet.
I read something from Robert Reich a couple of weeks ago about a proposal to get money out of politics by working with states to make some declaration about corporations not being able to contribute. I'm trying to remember the details. I'm forgetting the details. But does anybody know about that? Does it make any sense? I'm not a lawyer, so I don't know.
Can you say that again, Janet? Maybe is Alan Fierce still on, or Ed Wall? I have a couple of lawyers here.
And was it Robert Reich saying that by states acting individually, by declaring corporations unable to contribute to politics or something like that? I'm trying to remember exactly what he was proposing, but it was state action that could overcome Citizens United.
Yeah.
Okay.
And I don't know
Larry Lessig is also working on that out of Harvard. It's not going after Citizens United. Larry Lessig differs from Jeff Clements in that regard. Jeff Clements has been pushing for a constitutional amendment to reverse Citizens United for many years. Larry Lessig is taking a different approach, and it has to do with controlling the money that corporations can spend in politics. And it'd be interesting to take a look at that and what Robert Reich is saying. So thank you for that. I'll be looking into that because I think it's important.
Yeah, and this is certainly different from citizens, having a new constitutional amendment, which is, so hard to happen.
Yeah, thank you. Thanks, Lana, for that. Any other thoughts about local work or for polluters pay here in Massachusetts? Andy.
I just want to make a comment about electrification. I don't know. I'm always struck by the climate deniers, and I think we're going to get another big wave of El Nino in the summer, late summer and fall, where we're going to have droughts and wildfires and thunderstorms and all that. So I hope we get rid of a few climate deniers. But I look at Europe and the UK. Of course, they have the war. The pipeline got blown up, but they've had a tremendous growth in solar panels. and heat pumps, and they've been forced to adapt, and especially Africa is growing with solar panels. They're all Chinese solar panels. Our government is taxing the Chinese solar panels. We should be trying to import as many as we can. But I'm thinking, why can't we push the state to do more on solar programs? We need to try to, that I think a lot of the people are going to have to invest, a lot of the towns, maybe counties or whatever, county batteries sort of thing. But I think that would be a big push in reducing pollution from transportation and all that, just to have more electricity. People could charge their cars at home. That's all I have to say.
Yeah. And there is some legislation that's going to be moving through in the energy bill. You might want to take a look at it. It's still in process, has to go through the Senate, but there are opportunities there to push solar, and there's interest in the legislature to do that. So, great idea.
Any other comments or
Well,
announcements or?
I do have another quick comment. And then, okay, it's late. So I think we do need to make an effort to push polluters pay at the state level, but also just in general, to talk about the issue of money in politics. I think that is a huge, huge issue. And I don't personally feel that we're going to get out of this mess unless we start tackling that. I know it sounds like a whole new avenue in some ways, but there have been efforts. I think that's something we have to continue to work on. That's all.
Okay, well, thanks.
The problem is that all of these issues are entangled and can't be separated. And so when we're working on environmental justice, we're working on economic justice.
Yes, that's true. And we need to keep going on it. And I appreciate everyone who came today and your participation. Thank you, Pam and Lana, again, for bringing Pat to the chapter meeting today. And for those of you that are hanging in there, just a reminder for the people on the leadership team, we have a little bit of work to do after. So stay on, people on the leadership team. And we'll see you hopefully on Friday for our legislative panel to discuss the future energy bill. So please join us for that. And again, the link is in the ECA Mass newsletter. So get out there, take a walk. It's going to be 70 degrees at 4 o'clock. Take in that sunshine and keep on with the keeping on.